me down, don't fight me down, yeah, yeah, yeah. My friend and them couldn't tell you about me. Good people, it's good people. We only want love and we circle, yeah, yeah, yeah. My family couldn't tell you about me. Good people, it's good people. We only want love. Well, every man make the choices. Yeah, yeah, yeah. I said we make sacrifices. Yeah, yeah, yeah. We block out the noises. Yeah, yeah, yeah. We have to forget the voices. One day we gon' make it. Yeah, yeah, you don't have to fake it. Yeah, yeah, I give you my best. I give you the chain of my neck. I give you my love and respect. But now hear the story. Is you vex with me? Like I do you something. Like I do you something. When I hear the shout now, is you vex with me? Like I do the wrong thing. Like I do you something. Oh, it's a good, good thing. I in a good, good spirit. I drink in a good, good spirits. The vibes right up to the limits. So don't hold me down, don't fight me down. Yeah, yeah, yeah. Good, good spirit. I drink in a good, good spirits. The vibes ain't cast in a minute. So don't hold me down, don't fight me down. Yeah, yeah, yeah. My friend and them couldn't tell you about me. Good people, it's good people. We only want love in the circle. Yeah, yeah, yeah. My family couldn't tell you about me. Good people, it's good people. We only want love. I am on land pose like you never do bad. Things where you do say you never do that. Run for the cream and you never look back. Now money in your pocket so you never too sad. Boy, if money make you dance, you'll be dancing forever to the beat of a drum that never go help you. But now hear the story. Is you vex with me? Like I do you something. Like I do you something. When I hear the show now, is you vex with me? Like I do the wrong thing. Like I do you something. Oh, it's a good, good thing. I in a good, good spirit. I drink in a good, good spirits. The vibes right up to the limits. So don't hold me down, don't fight me down. Yeah, yeah, yeah. Good, good spirit. I drink in a good, good spirits. The vibes ain't cast in a minute. So don't hold me down, don't fight me down. Yeah, yeah. I in a good, good spirit. I drink in a good, good spirits. The vibes right up to the limits. So don't hold me down, don't fight me down. Yeah, yeah, yeah. Good, good spirit.
What are you doing?
She said, she said, let me cater to you. I say cater to me. She said, just relax and let me get it in. No, no, no. She said, take it easy, I will do the work. You don't have to wind up yourself. You don't have to wind up yourself. Oh, she said, take it easy, I will do the work. You don't have to wind up yourself. You don't have to wind up yourself. Oh, and then she bubble and she bubble and she bubble and wine. Push back is the greatest battle. Push back. Roll your waist and bend over. Push back. Oh, Miss Lady, bubble and she bubble and she bubble and wine. Push back. Give me the greatest battle. Push back. You are the wickedest battle. Push back. Why?
I wanna wine on your bumper. I know you like steam. I know you like vibes. I know you like speed. Clockwork, y'all bend down, touch your knee. It's a new wallpaper for my iPhone screen.
She said, let me cater to you. I said, cater to me. She said, just relax and let me get it in. Yes, girl, I wanna get it in. She said, take it easy, I will do the work. You don't have to wind up yourself. You don't have to wind up yourself. Oh, she said, take it easy, I will do the work. You don't have to wind up yourself. You don't have to wind up yourself. Oh, and then she bubble and she bubble and she bubble and wine. Push back is the greatest battle. Push back. Roll your waist and bend over. Push back. Oh, Miss Lady, bubble and she bubble and she bubble and wine. Push back. Give me the greatest battle. Push back. You are the wickedest battle. Push back. Oh,
who are the rubber waist? Like a rubber band. You have your own things. You never rubber man.
and when you put on your costume back and all, every man want jam in your section. She said, let me cater to you. I said, cater to me. She said, just relax and let me get it in. Yes, girl, I wanna get it in. She said, take it easy, I will do the work. You don't have to wind yourself. You don't have to wind up yourself. Oh, she said, take it easy, I will do the work. You don't have to wind up yourself. You don't have to wind up yourself. Oh, and then she bubble and she bubble and she bubble and wine. Push back is the greatest man. Oh, push back. Roll your waist and bend. Oh, push back. Oh, Miss Lady, bubble and she bubble and she bubble and wine. Push back. Give me the greatest man. Oh, push back. You are the wickedest man. Oh, push back. Oh.
Panorama, beat the road like panorama. Heart I love, but I love me bacchanal. Love a bacchanal bad. The place mash up when we start to get on bad. Look the girl them ready, ready, ready. Look the truck man rolling, rolling, rolling. And there's 1,000 girl tongue in tongue. Whole day we drinking rum. Tell them no slow it down. No, look how we beat it road like this panorama. 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 Inside the air. Look how we beat it road like this panorama. 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 Inside the air. Come on, we stand in that canal right now. Take a jump and I'll wind down. Tell them it's the time of the year. And we know this. Stand in that canal right now. Take a jump and I'll wind down. Tell them it's the time of the year. And we know this. Tell them we born bad, mashing up everywhere. If they feel them more mad, you will follow we play. And we go in. And we go in. And we go in. Something about the pan when you hear the song. That is the new carnival coming round. Give them pan men a round of applause. Oh God. Look, the girl them ready, ready, ready. Look, the truck man rolling, rolling, rolling. And there's 1,000 girl tongue in tongue. Whole day we drinking rum. Tell them no slow it down. No, look how we beat the road like this panorama. 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 Inside the air. Look how we beat the road like this panorama. 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 Inside the air. Come on, we start the back canal right now. Take a jump and I'll wind down.
Leader of the People's National Movement and the leader of the opposition, the Honorable Penelope Beckles-Robinson.
Testing.
Special good evening, ladies and gentlemen, here in Point Fortin this evening. Ladies and gentlemen, welcome to this national consultation on Stand Your Ground legislation hosted by the People's National Movement, held here in Point Fortin. Ladies and gentlemen, as we move forward, I would like you all to firstly just pay attention while we play a safety briefing for your information.
Your attention, please, ladies and gentlemen. Welcome to the Point Fortin Borough Corporation's auditorium. These rules are necessary to ensure your safety and optimum convenience while using our facility. The exits are located to the left of the auditorium. Please take a moment and identify the exit closest to you. Should there be an emergency, please use the exit at the front of the auditorium, which will take you to George Road, or the exit at the middle of the auditorium, which will also lead left to George Road. Please converge at the primary muster point located at the car park next to the municipal police station. Please be advised, there are no drills planned for today. The washrooms are located as follows. The female washroom is to the left and is accessible from within the auditorium. The male washroom is located at the bottom of the stairs to your left. Thank you for your kind attention and do enjoy your stay at our facility.
Thank you. Ladies and gentlemen, can you all please stand for the national anthem? Thank you, ladies and gentlemen. I invite you to remain standing as I ask to come and say our opening prayer, Alderman Kobe Sandy from the Point Fortin Borough Corporation.
Thank you, Mary. Let's bow our hearts in prayer. Thank you, Father, for a wonderful day that you have made today. As the word said, we will rejoice and be glad in it. As we gather today to, of course, have this important conversation, that you will guide our discussion here today. We will be, of course, guided by your spirit. It should be fruitful, it should be well and edifying to our souls. And you and we pray in Jesus' name, amen.
Ladies and gentlemen, you may have your seats. Thank you very much. And ladies and gentlemen, it is truly a pleasure, as I said, to welcome you all to this, our third national consultation on Stand Your Ground legislation. Today, we are in the bustling borough of Point Fortin, and it is really our pleasure to be here, and it is our pleasure to welcome you. But before I move forward, allow me to acknowledge the Honorable Penelope Beckles Robinson, political leader of the People's National Movement and the leader of the opposition. The Honorable Nian Gatsby Dolly, Member of Parliament for St. Anne's East and the Lady Vice Chairman of the People's National Movement. Ladies and gentlemen, we also acknowledge all other party officers who are here this evening, deputy political leaders, and I must acknowledge as well Deputy Political Leader Jennifer Baptiste Primus, Mrs. Jennifer Baptiste Primus, Deputy Political Leader Sanjiv Boodhu. I also acknowledge the Assistant Secretary, Ms. Patricia Alexis, here with us this evening as well. And also, we cannot forget our Operations Officer, Ms. Irene Hines, and Youth Officer, Kareem Marcelle. And ladies and gentlemen, we are pleased to also welcome His Worship, the Mayor, or in fact, the Mayor would welcome us in his borough, His Worship, Alderman Clyde James, Mayor of Point Fortin. Thank you for having us here, Mayor. Members of Parliament, Senators, heads of local government corporations, especially members of the Point Fortin Borough Corporation and other councillors who are here with us today. Specially invited guests, ladies and gentlemen, members of the media, and those viewing live on social media, on YouTube, and on other streaming platforms, a special good evening to you all. My name is Vyash Nandlal, and I will be your moderator for this evening's national consultation on Stand Your Ground legislation hosted by the People's National Movement. I welcome each of you who are in attendance here today at the Town Hall Auditorium of the Point Fortin Borough Corporation. Today's consultation, in keeping with the PNM's objective of educating, informing, and especially listening to you, the members of the public, is designed to be interactive and allow for a discussion with our panel, as well as to hear your views on this very serious matter of national importance. In our format, of course, I am bringing some opening and welcoming remarks to you, but this will be followed by a brief presentation on Stand Your Ground legislation, which is before us and which is before the Parliament. Our panel of experts, who I will then introduce, will then assemble and engage in what is hoped to be a very fruitful and a very enlightening discussion. We then get to hear from you, the members of the audience, as you would have had an opportunity to be informed, to listen to our panel of experts and our presentation. And it is the hope that that presentation and that discussion will generate questions and comments from you, the members of the public. You will have the opportunity to pose your questions and have answers, and hopefully engage in a very fruitful dialogue and discussion on this matter. So, ladies and gentlemen, without further delay, let us commence our program. And ladies and gentlemen, we have our panel who look very familiar to you. I'm sure who most of you would already know, but I will introduce them. Ladies and gentlemen, our first panelist is the Deputy Political Leader of the People's National Movement. He is an attorney at law and a very dedicated servant of the people and advocate for progressive policies. He brings both legal expertise and a deep understanding of governance to the table. His perspective on how this legislation intersects with national priorities and the lived realities of citizens will be invaluable for our conversation at hand. Ladies and gentlemen, please give a round of applause and welcome Deputy Political Leader of the People's National Movement, Sanjiv Boodhu. Our second panelist is a distinguished attorney at law again, with a career focusing on criminal law, but spanning civil, family law. She's a dedicated legal practitioner who combines academic excellence with practical expertise, holding a master's degree in corporate and commercial law with a distinction. Beyond her practice, she's also a trained mediator, having brought her skills to important institutions such as the Judiciary of Trinidad and Tobago and the Office of the Director of Public Prosecutions. Her breadth of experience and commitment to justice makes her a valuable voice on this panel. Ladies and gentlemen, please join me in welcoming Senator the Honorable Janelle John Bates. And finally, ladies and gentlemen, our next panelist, another attorney at law, but with a very diverse background. He has chosen to dedicate his efforts as well to community service and service to country. His legal practice has provided him with expertise and experience in criminal defense, constitutional, and civil law, facets which will certainly prove vital in this panel discussion today. He is a youth representative and an advocate for youth issues. And in 2025, this year, he was elected as a member of parliament and remains one of the youngest members of parliament of the House of Representatives. Ladies and gentlemen, please join me in welcoming to this panel and here in Point Fortin, the Member of Parliament for Laventille West and the Youth Officer of the People's National Movement, the Honorable Kareem Marcelle. And ladies and gentlemen, we move straight into the other section of this consultation, this national consultation on Stand Your Ground legislation, because we have heard a lot of discussion about it. We have heard a lot of talk about it. And today in point 14, we are here to bring some information and most of all, to listen to you, the members of the public, on this very important matter. But firstly, we have a presentation on this vital piece of legislation, and we are hoping that our presenter will shed some light and will be able to stir more discourse and discussion on this matter. I would like to invite to the podium to present on Stand Your Ground legislation the Honorable Kareem Marcelle.
Thank you very kindly, Mr. Nandlal. Allow me to stand on the protocols previously established, but to recognize our distinguished political leader of the People's National Movement and the leader of the opposition, the Honorable Penelope Beckles-Robinson. And because I am also in the borough of Point Fortin, Consultation, I want to recognize, of course, His Worship the Mayor of Point Fortin, Alderman Clyde James. Ladies and gentlemen, the country is on the verge of considering and perhaps even coming into law a bill that is popularly called the Stand Your Ground legislation. The bill is actually entitled A Home Invasion, Self-Defense and Defense of Property Act 2025. This bill, it's important to note that while this bill is being proposed at the moment as we speak, so anything that we say here in terms of the proposed bill, it is important to note that it is not the current law. The government has indicated that before the end of this year, that the country could expect to see the Home Invasion, Self-Defense and Defense of Property Act Bill of 2025 being laid before the both House of Parliament. And we may ask, well, why is consultations important in terms of this bill? And if the government already has the majority, then could it pass on its own with the government support alone? So this proposed bill will interfere with and touch and concern Section 4 and Section 5 of the Constitution in terms of those are the two sections of our Constitution in which our enshrined rights are protected. And any bill that Parliament seeks to pass that touches and concern or interferes with those or infringes upon those sections in the Constitution, you are required specifically when it relates to this bill, to have a 3/5 majority in both the House of Representatives as well as the Senate. So in the House of Representatives, the 3/5 would ordinarily, in terms of the current composition of the Parliament, it means that the government of the day can pass this bill easily in the House of Representatives. However, when it goes to the upper house or the Senate, it requires 3/5 majority there. It would mean, therefore, because the way that the upper house is formed, you have 16 government senators, 15 government senators, 6 opposition senators, and 9 independent senators. It would mean that you are looking at around 18 or 19 senators to vote for the bill in order for it to be law, which would mean that you would need at least the support of a minimum of 2 opposition, either opposition or independent senators. It's very, very important as opposition. We are not an opposition that will oppose for opposing's sake, and it's important that we come to you to hear your opinion so that it will form it will inform our decision in terms of how we vote. All right. So there is, as we speak, the common law that provides and offers defense, self-defense for both yourself as well as in terms of your home, in terms of your property, and it is formed under what we call the common law. So the difference between, so on one side you have the common law and on the other side you have statutory law. Common law is a body of rules and decisions that was formed by way of past judgments. So before becoming an independent nation, we would have, of course, be under British rule, and therefore most of our case law comes from the United Kingdom. And now the common law forms part not only of the UK, but in terms of our Commonwealth. All right? And as opposed to statutory law is the law that we pass in Parliament. So it's from the Constitution, come down to every piece of legislation that passed through the House of Parliament, proclaimed, and becomes written law. So the government is seeking to standardize in terms of the stand your wrong legislation by way of statutory law. But right now we have common law, which is easily accessible and available to all members of society. So what does the common law say concerning your right to self-defense? This law is currently governed by what we call the castle doctrine. Castle is often said that a man's home is his castle. So the castle doctrine is a legal principle that allows the individuals to use reasonable force, including deadly force when necessary, to defend themselves against intruders in their home, and there is no duty to retreat currently. The doctrine goes hundreds of years back. In fact, the very first case was in 1604, where the castle doctrine was introduced. And the judge in that case said, a man's house is his castle. The house of everyone is to him his castle and fortress, as well as for his defense against injury and violence, as for his repose. If thieves come to a man's house to rob or murder, and the owner or his servants kill any of the thieves in defense of himself and his house, it is no felony, and he shall lose nothing. So we have to look at the degree of force in terms of the common law doctrine. What is the degree of force? So at common law, the person standing his ground in his home in defense of himself, his family, his guests, or his property is allowed to use such force as reasonable in the circumstances as he believed them to be. So in other words, the degree of force used must be proportionate to the attack, that you believe is taking place. So if someone, for example, enters your home or enters your yard to thief your Judy Mango or your Zaboka or whatever the case may be, and that person, let's say it's a child, and that child is not armed or anything of that sort, it would be unreasonable to come out with your matic, load it up, and knock it on that child again and again and again, because it must be proportionate. But if you take, for example, if you take the child's hand and you speak to the child, put the child out, it's different. And of course, you don't expect if someone breaks into your home, comes in with a gun, that you would ask them to leave. It just doesn't make sense. You would have to, of course, use force that is proportionate in these circumstances. So what is bandied about is that there is some big difference between the proposed law and the common law in terms of the duty to retreat. To be elusively clear, there is no duty to retreat at common law at present. At common law, as long as the force you use was reasonably justified in the circumstances as you believe them to be, you would not be required to retreat. However, when the court looks at the factors to determine what was reasonable in the circumstances, the court will consider whether, in fact, you had an opportunity to retreat in these circumstances or not. It is not one deciding factor, but it's a list of factors that the common law have developed over time. So many persons may ask, if somebody comes into your home tonight or tomorrow where the proposed bill is not in effect yet, what can they possibly be charged for in terms of the attackers? So without standing wrong legislation, persons unlawfully entering your home, trying to attack you or whatever the case may be, can be charged for offenses such as robbery, if they came to rob you, larceny, if it's in a case where there's no contact with the victim, housebreaking, if no one is home, burglary, as well as if you or a loved one would have passed away, would have been killed by way of that intruder, that person can be charged for murder. So there are protections in terms of if persons enter your property today or tonight or tomorrow and commit these offenses, that both the common law as well as statutory law would protect against they getting a slap on the wrist. All right. So the government is now proposing. So now that I've told you what is the common law position and give you a better understanding of what is our position as of today, we now have to look at what is the proposed bill. What is the proposed bill going to do different? My preliminary opinion, based on comparison to the common law as well as to this new bill, is that it's an attempt to codify what is the existing common law, but with a few exceptions. So we would look at that. So I want to look at some important clauses in terms of the bill. Section 5A, A to B of the proposed legislation deals with who the bill seeks to protect. So it says that subject to the provisions of this act, an occupant who is in lawful possession of a dwelling house in which that person has a right to be at the material time has no duty to retreat from a home invader at the dwelling house, and that person also has the right to stand his ground and use or threaten to use defensive force to protect himself, another person, or his property from a home invader. So the word that I want you to focus on is an occupant. And the definition section in the bill would have explained who is an occupant. Because if you're saying that an occupant is someone who is in lawful possession of a dwelling house, we know that in many parts of the country, there are places where persons may be squatting. They may be occupying a piece of land or a structure that is not theirs. And therefore, the law may perceive you to not be somebody who is in lawful possession of the dwelling house. So the definition section of the bill defines occupant to mean a person in lawful possession of a dwelling house and also includes 1, the owner, occupier, tenant, or any other person having the control or management of a dwelling house. B, an immediate family member of an occupant who resides at the dwelling house, either permanently or temporarily. C, a person who resides either permanently or temporarily in a dwelling house with the express provision of an occupant. D, a person who, at the material time, has a right to be at the dwelling house, is in the employ of the occupant, as the occupant's under the occupant's direction for any purpose, or is responsible for an occupant's care and support, either on a temporary or permanent basis. Or E, a person who at the material time is visiting a dwelling house as an invited guest. So these are the class of persons in terms of if you're asking yourself whether you are in a position to stand your ground with this proposed bill. If you do not fall under any of these categories, you are simply not protected by this proposed bill. You may have, of course, recourse in terms of protection available to you in the common law that exists currently. So, who the bill makes an offender? So, who is the person? The only persons who are committing home invasions, which is outlined in Section 6 of the Act. And Section 6, A to F, basically outlines that a person who commits a home invasion if he, A, unlawfully enters an occupied dwelling house when he knows or has reason to know that one or more persons is present in the dwelling house. B, unlawfully enters a dwelling house and remains therein until one or more person is present in the dwelling house. C, fraudulently represents himself to be a member of law enforcement authority or a representative of any other public or private entity for the purpose of gaining entry to the dwelling house, which just means is that many times you would see certain advisory going out that persons, let's say, are not from a specific agency such as TNTEC or TSTT or whatever the case may be, posing that they have the authority to come into your house, and when, or even in cases where persons dressed as police officers or members of the defense force show up by your home and gains entry into your home, so you allow them to come in thinking that they are who they say they are, but when in fact they are not. So the law also provides for instances where you allow those persons to come into your home and they turn out to be imposters. Right. D is invited into an occupied dwelling house and fails to leave immediately on being asked by an occupant to do so. And E enters an occupying dwelling house and then forms the intention to commit a serious criminal offense. That is what is different. At common law, a home invasion is not classified. So you are only required to invoke self-defense mechanism when your life becomes, when any circumstances where you believe your life is in imminent danger and you respond appropriately. What the bill seeks to outline is that from the moment a home invader, somebody who you believe is a home invader, steps onto your property, then you would have the right, based on the circumstances, to act in a certain way. And we'll get to what are some of those circumstances, as well as how can persons who are attacked respond in light of the circumstances, which we can find at section 7(1), subsection A to C. All right. So just briefly, this will be the last piece of the legislation that I would go through in terms of reading, but it's very important for you to know what the proposed bill entails and to know whether you fall under these categories in terms of what are your rights as a home invader, as an occupant of a home where a home invader comes at your doorstep. So how can an attacked person respond? Section 7(1) gives us that action. So subject to section 10, an occupant has no duty to retreat and has the right to stand his ground against a home invader. Remember that I told you in common law, there is also no duty to retreat. So the same thing in terms of what is qualified on the bill is that there is also no duty to retreat. Right? So if the home invader invades your home, use or threaten to use force against the home invader, you can use, and of course, use force against the home invader where the occupant believes on reasonable grounds that one, that a force was being used against him or her or another person, or that a threat of force was being made against him or her or another person, or that his life or the life of another person was in immediate danger or threat of danger, or believes that his actions were necessary and reasonable in order to defend or protect himself or another person from the use of threat or force, and lastly, establishes that the defensive force used was proportionate to the threat that he honestly believed to exist. So so this is what, in terms of what are some of the considerations you have to use as a home occupant or owner in terms of how you're going to respond to an attack. So I know there has been a general perception that anybody come on your property, whether it is police, doctor, TNTEC, you can just load up your matic and empty it on that person. You will be charged. The difference is, you have to ask yourself, what changes does this new bill propose to bring? So the new offense of home invasion is one of the things. One can use a greater amount of force in repelling attack under the new bill, because at common law, the force that you can use must be reasonable and proportionate. However, the bill proposes that the level of force that you can use is that it must be reasonable, but disproportionate is okay, but once it is not grossly disproportionate. So it must be reasonable, but it must not be grossly disproportionate, as opposed to common law, where, of course, you have to be reasonable and proportionate. The court and the judge will have to look at all the circumstances and determine whether your force was gross, or the jury to determine whether your force was not grossly disproportionate. So that briefly, in terms of some of the shortcomings of the bill, even if you reasonably stand your ground, let's say someone break into your home, they had a knife, they had a cutlass, you felt threatened, and you went for your firearm, and you went ahead and killed that person. One of the shortcomings is that there is no immunity hearing. Most of the other jurisdictions where you find stand your ground legislation, you have what we call immunity hearing. And this is basically where, at a very early stage of the proceedings, if you are a homeowner and you are charged for the offense of murder, or robbery or shooting with intent, or whatever the case may be, you can come before the court at a very early stage, in a prima facie setting, and tell the court, here's what, I want to invoke my right as a home owner, that my life was under threat. I would have relied on the provisions in the stand your ground legislation, and I would have used force that I don't believe that was grossly disproportionate. And I'm asking you, based on that basis, to allow me to be free at this time. This legislation doesn't have that. So what will happen is, if you are in fact, if you have found yourself in a position where you have shot and killed a home invader, and the police investigator believes that your response was not grossly, was grossly disproportionate, or believe that you do not have the defense, because simple things as if you have an illegal firearm, you're not entitled to invoke this law. If you are under the influence of alcohol or drugs, you are not able to rely on this defense. So there may be other circumstances where the police may be of the opinion that, all right, this is not a case where it is a genuine home invasion and we are going to charge you. When the police charge you and they take you to court, it is very unlikely, because it's a very high threshold for you to get bail for murder. It is very unlikely that you will get bail. You would spend years in jail before you get, sometimes within a year or two, you may get what we call a sufficiency hearing, which will determine whether there's enough evidence for you to go to trial. And when you go to trial, most of the times it will pass that threshold. And when you go to trial, you may have to wait years before the prosecution presents its full case and say at the end of it to the members of the jury, I rest my case. It is only then and there you could bring the defense or try to invoke your right as a home invader and to rely on the protections in this legislation. So that is one of the major shortcomings. So we will listen to you. I hope I've provided you with a lot of information so that it could, of course, give you some thoughts and some questions that would help the panel to better explain. We are here to listen to you. We are here to note your concerns, and we promise that your opinions would also form part of our discussions as members of Parliament and the party to take our official position. So I thank you very kindly for your attention.
Thank you, the Honorable Kareem Marcelle, for that very insightful presentation on this often misunderstood piece of legislation. So, ladies and gentlemen, we will now move into a brief panel discussion where I will ask the panelists to give their perspectives on different aspects of this bill. And in doing so, they could further inform and enlighten you. And after that, we would move into the section where we hear from you, the members of the audience, and even those who are live on social media, where you will be able to ask questions and make comments based on the discussion and based on your understanding. So going straight in, and I want to bring Senator John Bates into the discussion. Senator, you have a unique perspective because you have a background in the Director of Public Prosecution's office. And we have heard, to quote a former panelist, there's jail in this bill. Given what has been said, and what has been proposed or maybe said on platforms regarding a bit of leeway and freedom to act in self-defense compared to the reality of this bill. Can you give your perspective, especially given your background?
Testing. Hello, good afternoon. Yes, good evening, everyone. Thank you for the opportunity to engage in this panel discussion. Now, my initial thoughts about this bill is twofold. Firstly, it is not a license to kill. It doesn't give any and everybody the license to kill any and anybody on their property that they feel shouldn't be there. And it's also not a remedy for the scourge of crime and the scourge of home breaking or home invasion in our country. And I say that for those two things, they're linked. I say those two things for several reasons. Firstly, as pointed out by Member of Parliament, Mr. Marcelle, and as you just indicated, there may be jail if you kill someone on your property, if you do not look at some of the exceptions of this act. Firstly, if somebody is on your property and they are killed, the police they have to investigate. So it's not a matter you say, hey, this was a home invader, and the police say, oh, really? You own here, you occupy here, he lives here, and that's it. No, they have to do a proper investigation. And if they believe, as was indicated by Mr. Marcelle, that maybe your force wasn't reasonable or whatever other reason, you can be charged. And he has given you the ramifications for that. And I believe he did also mention the fact that unlike in other jurisdictions, in this jurisdiction, this bill does not have what is called an immunity hearing. So you do not have the right to appear before a judge early in the process to raise this defense. You have to wait until your trial date. And at this point, I will want to say kudos to the past government, under the PNM administration for making some critical changes in our judicial system. Mr. Marcelle would have indicated that before, if you were charged with murder, you have to wait years. And we mean years, because prior to the change in the law that came about a year or two or so because of the act that we call a JIPA, you'd first have to go through a preliminary inquiry and then a trial. And that is at the point where you can bring up your self-defense. Now, because of the change in the law, we no longer have preliminary inquiries. You get to your trial faster. However, getting to your trial faster could still mean a year or two that you may or may not be able to access bail to bring up this self-defense, this defense of self-defense. And the other reason why I say it's not a remedy for the scourge of crime is because there seems to be this idea when I speak with individuals that once this law is passed, we all get in our gun and we're ready, we armed and ready, and we could defend ourselves, we kill whoever. But again, I want people to be mindful of the exceptions to this act, which include whether or not you were under the influence, whether or not you were engaged in criminal conduct, also whether or not the person was who you were saying was a home invader was occupant, and whether or not your actions were grossly disproportionate. And lastly, this bill does not mean we are all going to be entitled to guns. People are making that connection, but this bill does not address how or who is able to acquire an FUL at this time. So I just want people to understand the limitations of this bill before they jump on the bandwagon. Think about it first.
Thank you, Senator. And to Sanjiv, I want to bring in the whole aspect of public policy and the fight against crime. And I want to ask you, where does Stand Your Ground law fit, or this law on home invasion, where does this fit in the overall public policy as a tool to tackle crime and criminality?
Thank you very much. Good evening, political leader, His Worship, the Mayor, members of Council, ladies and gentlemen, members of the leadership of the party, and of course, fellow panelists and chairman of this evening's proceedings. Thank you all very much for having me once again on the panel. Vyash, so, I mean, first of all, I want to endorse what my fellow panelist, the Honorable Senator, has said.
Your question invites me to point out that very, very frankly, that we cannot shoot our way out of a crime situation. That doesn't mean to say that we don't acknowledge that crime is a very serious issue, if not the most serious issue facing us as a society. And I mean, in recognizing that, we have to accept that any legislative intervention that is proposed in an attempt to address crime ought to be seriously considered. But in considering it, one has to consider the package that it comes in. And I think the package that this particular bill comes in is the definition of cat in bag. We've been told certain things that leads us to believe as a society that once this bill is passed, everybody is going to have a firearm and is going to be protected by the law once you use that firearm in certain circumstances. Whereas the law actually does nothing to address the situation of granting legal firearms at all. And so, as you phrase the question, well, where does this bill perhaps fit in a larger policy? Well, perhaps it might have been useful if the more pressing issues had been looked at, for example, the very firearm process and procedure. So the former government did embark upon an audit of the firearms unit or the firearms division of the TTPS. It did call for, the former Minister of National Security called for an audit, and the audit was underway. And obviously that was with the view of assessing where we are in the firearm application and granting process, how quickly are we processing applications, how many of those applications are granted, how many are rejected, and of those rejected, how many are appealed, and of those appealed, how many are successful appeals. And if we start there, then of course maybe this piece of legislation could be something that we look at. But insofar as you have no matic, then what is the use of telling people load up a matic and knock it on them? People simply don't have the matic to do anything with. Thank you, Sanjiv. Kareem, I want to come back to you. When we hear stand your ground, we think of places like Florida and other states in the US. But compared to the US, where they have the right to bear arms enshrined in the Constitution and a culture surrounding that, and Trinidad and Tobago seems to not have such a similarity, how do you expect laws like this to impact our society?
It is thank you very kindly, Vyash, for the question. We are a population of almost 1.4 million citizens. At this moment, the processes relative to applying for a firearm user's license is that you have to apply to the commissioner, pass through a long list of tests and so on. And as we speak, there are about 13,000 or so active FUL owners, right? So only 13,000 thereabouts of the citizens of Trinidad and Tobago have legal firearms, which means that when it comes to loading up the matic, most of them, I don't think any of them have matic, any automatic weapon, but they will have firearms. And those persons only are the ones that would be sort of affected by this rhetoric about loading up the matic and so on. But what it does is that it gives a sense of false hope that this bill seeks to grant or treat with the issues of delayed granting or approval of FULs, which is not in fact the case. We must ask ourselves whether our country and our culture, what would be the effects of flooding Trinidad and Tobago, even if that is a follow-up in terms of other proposed bill. What would be the effects of literally arming a country such as ours? We may see our neighbors getting away, and when they get away, a case of will come out and a cutlass come out. What are you going to do in every circumstance where there are firearms involved, and what is going to be the effect of that on our country? That is something that we have to look at drastically, where provisions are not being put in place for proper anger management from very young in our school to change our cultures and so on. So we have to look at the culture shift and shock, and to see whether, in comparing, as you asked, Vyash, concerning Florida and so on, there is research that showed, in fact, the Law Reform Commission of the Attorney General office published a report on this, and in the report they have stated that the research team examined the impacts of stand your ground laws in 23 states between 2000 and 2016. And according to that research, they associated with 8% to 11% national increases in homicide and firearm-related homicides. In particular, Florida saw an increase of 28% monthly rise in homicides. So if we think that our crime situation warrants putting more firearms into the hands of our citizens and telling them to shoot anybody that comes, these are the consequences that we are likely to have, probably even to tenfolds. Thank you.
Thank you, Kareem. Any of the other panelists care to respond to that, that topic? I want to ask just a final question before we go into the audience. And really, this question tries to bridge the gap between what has been said on political platforms and what has been said publicly in terms of what Stand Your Ground purports to do versus what this bill is actually giving citizens the ability to do and what is presented here. And we are asking, and it's been answered in the past, and I'm asking panelists just an open general question. What's the major difference between what has been said and what is actually in black and white? One, two, testing. Hello. Is it? Okay, right. You know, it is. Okay. Yeah. Thank you. All right. So let's deal first with what the bill does. The bill does two things. It creates an offense called home invasion, and it codifies the castle doctrine, which is no duty to retreat in certain circumstances, one of which, of course, if you are in lawful occupation of the premises when you are under attack. Now, in creating a new offense called home invasion, one must ask oneself if ever you are aware of a time when someone broke into somebody else's home, the police intervened, and the police let them go because there was no offense under which you could have charged them. Right? And I mean, if you think back, you've never heard that, simply because it's never been the case. Because you have the offenses against the person, you have the laws, I mean, all the acts that the MP went through, right? So the law deals with people who have invaded somebody's home unlawfully, right? The law already deals with that. And in respect of the castle doctrine, again, think of just in the last 8 months, think of how many times you would have read in the newspaper, in fact, including today I saw in the newspaper, where a licensed firearm holder would have used their weapon either to ward off or to actually injure somebody who they perceived to be an attacker and was arrested and charged with a criminal offense. All right? If you look back at the last 8 months, I don't think anybody was arrested. But for one, there was one recently. In fact, well, I was involved in that matter, and that's the only reason I knew about it. But I mean, generally speaking, somebody who is in lawful possession of a firearm and uses the firearm in the course of a robbery to defend themselves generally is not charged. No, that is what the law says compared to what the law is. Let's talk about now what the proposers of this law said about the law. The proposers of this law has said this law eliminates the need for an investigation. That is one of the things that the Minister of Legal Affairs has said. That, and he gave a whole example of it at one of their consultations, right? On, you know, if this, then this, and so on and so on. And maybe the police wouldn't even have to investigate. But that is starkly contrary to Section 7(2) of the Act, which says when determining whether the defensive force used was reasonable in the circumstances, the court shall take into account the following set of factors. All right, and a number of factors listed there. It tells you very clearly that a court has to consider certain factors when determining whether a homeowner who says he's acted in self-defense has in fact acted in self-defense that is protected under this piece of legislation. So it is completely untrue to say that no investigation can be conducted. In fact, if it is the government's position that the police are not to conduct an investigation, then it tells you that in the absence of an investigation, an arrest will result. But it cannot be that the police are being told, don't conduct an investigation,
and conclude that somebody has acted in self-defense. It has to be no investigation equals an arrest. And you, the homeowner, now, having relied on what they have said about the bill, finds yourself charged with an offense and having to raise a defense here and prove it. The burden now shifts to you, the homeowner, to prove that you acted in self-defense. I mean, that is one of the major misleading points about this act. And of course, the obvious one, which is the load up the matic. There's absolutely no talk about matic here. That this bill simply does not introduce to anybody in the population any better entitlement to a legal firearm, any more efficient process to apply for and obtain a legal firearm. It simply does not do that. It's just misleading to the population. It is irresponsible. It inflates excitement in the population that they may act a particular way under certain circumstances, legitimately expecting protection under this act when there is no such protection coming.
Thank you, Sanjiv. Do we have any other comments on that from any of our panelists? Okay. Thank you very much. So, ladies and gentlemen, with that brief discussion, I'm hoping that it would have found fertile ground with you, the members of the audience, and you who would have been viewing live as well on social media. And we now enter the interactive discussion stage of our national consultation on Stand Your Ground legislation hosted by the People's National Movement. But before we go into that, I would like to go over some ground rules as you come forward to make your interventions and your questions, pose your questions. I ask kindly that you please limit your question to at least one question or comment per person. We ask that you limit your question to within 1 minute. And of course, this is on Stand Your Ground legislation, so we ask that you stick to the issue. We ask that you minimize preambles and be very direct in your questioning. We ask that you go through that persons tend to have the tendency to go through the protocols, simply saying all protocols observed or I stand on the established protocols will be sufficient. Above all, we ask everyone, remain respectful at all times. If the moderator needs to intervene, I will, to bring the discussion back on track. So ladies and gentlemen, with that being said, we have a mic to my left, and we ask members of the audience, if you have a question to pose, feel free, please line up in an orderly manner. I will call upon you. I will ask you to give your name and location. That could be your constituency, and that you pose your question or your comment. Our panel is eager to take your question. So the floor is open now, ladies and gentlemen. Yes, sir.
Yeah. Hello, good night. My name is Clive Alexis from Fortin here. I want to ask this question. I want to know why bring the bill without the protection of early immunity hearing for one to be heard, to know where one stands, to know if one is right or wrong using Stand Your Ground. Yeah. Why not remain as it was in to police have the police still have to have the investigation. Police still have to make the decision. You know, as it is right now, the police have to make the decision if it's self-defense or not to be charged. And to me, it's the same thing. To me, it's the same thing, you know? So why bring it in without that protect that early? Because if you're innocent, you still have to go through these years in a cell to know whether you're...
Yeah, thank you, sir. So I will ask the Honorable Kareem Marcelle to answer that question.
Yeah. Thank you very kindly for that question, sir. Just to be clear, you're asking what is the sense of the immunity hearing when the police may still have to investigate, charge. With all the immunity, with all the immunity hearing, I think that I agree with your, I agree 100% with your concerns, because immunity hearings are very, very critical to determining whether you could raise and invoke this defense. If you are telling me that the current law is that if you shoot and kill someone in your home, that the police have to come to the scene, coordinate off crime scene investigators. They may take your firearm. Although I heard the Minister of Legal Affairs said that they wouldn't have to take your firearm. That's absolute nonsense. I don't know who is advising them. But nevertheless, in cases where the police come to your home, they investigate, they will take your firearm. They would have to go through the whole crime scene. They may even arrest you based on a preliminary position. They would interview you. They may take interviews from other persons, and you may end up, when they go to the office of the DPP, being recommended that a charge of murder be laid against you. And if you are charged with murder, you go before the court, the High Court, and you have to go what we call a scheduling order. And that scheduling order would give the prosecution what time to bring in what evidence they have, and you file it and serve it on your attorneys. And then your attorneys will have to make what we call a preliminary no case submission to say whether there is enough evidence against you or not. But even at that time, your attorney cannot bring up any possible defenses, because defenses only come after when you reach a trial, which is years down the road. Once it reaches that point. And of course, if you reach to that point and the state does prove their case, then only you would be able to raise that defense. This bill does not take care whatsoever into consideration the immunity hearing, which is a critical aspect in most of the other Commonwealth and outside of the Commonwealth, like in states like Florida, where this is implemented. So I agree with you, and I believe that this should form part of the discussion when considering stand your ground legislation.
Thank you, MP Marcelle. I believe we have another question there, ma'am. Name and location.
Good night, everybody. Claudia Maguire, Wapo to be exact, constituency of Point Fortin. In Point Fortin, most of the lands are state lands. And as such, a lot of persons in Point Fortin do not have lawful ownership. So how am I going to use this law to protect myself and family when I do not have lawful ownership?
Okay. Sanjiv?
Oh, okay. Thank you very much, ma'am, for the question. If I understand you correctly, asking how can you access a defense under this legislation if you don't own the parcel of land on which you live? All right. So ownership and occupation are two different things in law. This bill does in fact cover occupants, and they have a series of definitions of occupants, right? Of course, owner being one, but also you can be covered if you are a person who resides either permanently or temporarily in a dwelling house with the express permission of an occupant. An occupant can be considered any person having the control or management of a dwelling house. So let's be practical here. In circumstances in which you have occupied a parcel of land for which you have no deed or certificate of title, and you've constructed a home on it and you've been living there for years and years and nobody has raised a challenge to you, there's no dispute in law as to whether you are a lawful occupant in that regard. Right? Unless, of course, a civil action is initiated by somebody holding themselves out to have a better title to that parcel of land than you. But that type of scenario does not arise in the criminal arena, at least ostensibly so. There must have been some other factor existing for you to not be taken on the face of it to be the lawful occupant. And to be even clearer, it is rather easy, again, in the criminal arena, to determine of two people in a situation where someone is accused of being an intruder, or of those two people, it is rather easy to determine which of them is the lawful occupant and which is the intruder. So where it is likely for a dispute as to who is the lawful occupant to occur is where you have situations between family members or even neighbors sometimes, where you have people who are familiar with one another using violence against one another, and then one of them, the successful one in the dispute, attempting to raise a defense under this particular bill. That is where the waters tend to get muddy. And of course, if that is the case, it will be incumbent upon you, the defendant, at that point in time, to prove that you were in fact a lawful occupant, albeit you may not be able to prove that you have a deed or a certificate of title or a court order. You can still prove you are a lawful occupant. So I really hope that answers the question. I know it's a rather long answer, but I've tried to cover all of the possibilities there.
Thank you, Sanjiv. And the floor is open again. Yes, sir. You can give your name and location.
Good night, everyone. I reside in Labrie. My name is David Tate. The learned senior counsel, Mr. Anand Ramlogan, said in another place, he argued that the current self-defense laws in Trinidad and Tobago unfairly place the burden of proof on victims. The current state of the law is that if someone invades your home, your vehicle, or your private personal space, the law of self-defense supplies. That means that you have to prove that you did not use excessive force. But the burden of proof is on the victim. I would like you to expound on what Mr. Ramlogan has placed in public space for understanding by me.
Okay, thank you, sir.
Thank you, Mr. Tate, for the question. All right, so the question is whether the burden is placed on somebody claiming self-defense currently in the existing law, and whether that person is now, as a victim, having to prove that they've relied on self-defense. Let's go back a little bit in our scenario situation here, right? So somebody has come into your, broken into your home, you've used your licensed firearm. Let's keep it simple. You've used your licensed firearm, you've shot them, they've died, right? This is currently before the existence of this bill. The police will conduct an investigation, and it is only after that investigation, if there is prima facie evidence, which means evidence that is on the face of the investigation, that you have acted unlawfully, you've acted in a situation that is not self-defense, you've acted maliciously, you've acted unreasonably, disproportionately, all of those things, will you then be charged? If the police, based on the investigation, have concluded that you have acted disproportionately, you've acted unreasonably, you've acted maliciously. If they've determined that by way of an investigation and then they've charged you either for wounding with intent, or even murder if the person has died, are you then really a victim? You are saying to the police, well, a man has broken into my home and I shot him. But the police investigation determined, well, your door was open, it's 12 o'clock in the daytime, the person you've said invaded your home is in fact your neighbor who you know for the past 30 years. He was unarmed, he was bareback, and last week, you and him had an argument because he spoke to your wife a little too kindly. If those are the circumstances under which you're telling the police, well, I shoot the man because he was a home invader, and that's the information the police have, well, certainly they're going to charge you, and you're going to have to prove your self-defense as best as you can before the court. Is it fair then to say that you are a victim there? I don't think so. Now, on the other hand, if no investigation at all is conducted, which is what is being bandied about, an absence of an investigation, well, how are the police going to determine who is telling the truth and who isn't, especially if somebody is dead? So that my view is, if the police is not conducting an investigation, they are left with no choice but to arrest you immediately and let this act take its course and put you to proof of the requirements of Section 7, subsection 2 in particular. So that I don't know that the narrative, which is what we're coming back to, right? The messaging that we are hearing from the other side is really a practical messaging, or to a certain extent is even accurate messaging, whether it is the truth at all. It's easy to say all these sorts of inflammatory things because we as a society have become very, I think rightfully so, have become intolerant to the scourge of crime. That's the truth. But at the same time, when a government is communicating with citizens in a right-thinking and responsible society, they have to address us as such. They have to address us responsibly, truthfully, pragmatically, and realistically. And I think that is where we are having these types of problems.
Thank you, Sanjiv. So we have another question. And so we're asking members of the audience if when posing your questions, if you could speak a little closer to the mic so that we could hear you all. Thank you. Name and location.
Sure, thank you. Good night. Name is Leslie Chang from Point Fortin, Mahika. It's a bit difficult for me to not recognize our mayor. A pleasant good night to our mayor, as well as attending our audience, our political leader, members of council, and other members of parliament who are here visiting with us. Two questions, if you might be allowed, but I think you may have answered the first one already. Does the stand your ground legislation protect you or make a distinction between reasonable fear and malicious intent? And I believe that was partially answered already, because the stand your ground legislation, if it is used by somebody who is in that particular situation, they may either have malicious intent or they may say they have reasonable fear which made them enact in that course of action and use the stand your ground legislation to protect them. Question number one, I think that was partially answered by a member of the head table there already. Question number two is that in following the stand your ground legislation that is taking place across the nation, I was asking a lot of people. The government has embarked also on the stand your ground legislation conversations across the country. But I may be wrong, but have they brought that discussion to the areas that are controlled by the People's National Movement? It seems to me, and I am an error if I'm an error, say so, that this legislation and conversation by the government has so far only been brought in areas that are controlled by the United National Congress. I thought when we all win, when they win, everybody win. Because in Point Fortin here, a historic thing was done. They won the seat, the UNC won the seat, but like we didn't win enough for a conversation like that to come down here into Point Fortin for your stand your ground legislation by them. I'm so guided by the head table. Thank you very much.
Thank you, sir. Senator John Bates.
Hello, right, yes. I'll address the first question. I also wanted to address the second question, but Mr. Marcelle has indicated he would want to elaborate on that. As it relates to your first question, the reasonable fear versus malicious intent, in order for that to be addressed, then to me it seems obvious that the police must investigate, because you can't just shoot and kill someone in your home and just stand there and say home invader and that's the end of that, because as you would have rightly pointed out, someone might want to use that stand your ground defense or self-defense as is being purported in this bill to undertake an illegal action. So there must be an investigation, and it's for the police to make that initial determination, well, at least compile the investigation, go to the DPP, who would then make a recommendation. And if there is a recommendation to charge you, as Mr. Marcelle pointed out, you will have to then go before the court. And Section 7.2 guides the court as to the factors that they have to take into account in concluding whether or not you would have acted, whether your defensive force was reasonable in the circumstances. And they would look at things such as the nature of the force or threat. They would look at whether any sort of relationship between the parties. So if you want to use it to get back at your neighbor, they do take that into consideration, the nature and proportionality of the occupier's response to the threat and so forth. So again, it's not a matter unless, as being purported, there's no investigation. There must be an investigation to decipher whether there was a reasonable fear of something imminent or a malicious intent. And to quickly answer your second question, seems to me that they have not gone to any PNM areas, but I'll let Mr. Marcelle expound on that.
Yes, Mr. Marcelle.
Yes, sounds very kindly, Senator Bates. My initial response to the government's approach to the consultation around this very important bill, firstly, is that this ought to be a government approach, not a party approach, but a government approach. And because it threatens to undermine and or affect and potentially change the very social and cultural fabric of our society, it requires a non-partisan approach. However, we have noted very early that the consultations were in fact another Monday night forum. And we thought it proper, especially when we saw that if you're doing you're going around the country and you're doing consultations that will inform your position on a specific bill, that first to begin, the concept behind the stand your ground legislation should have gone out first for consultation before forming a draft bill. But even in the absence where there is already a proposed draft bill, and you are coming to the country and you are inviting contributions, then it will make sense where the government has said publicly that they're going to lay this very same bill as is in the parliament before the end of the year. Then you ask yourself, as a government, if you are asking and or soliciting ideas and concerns from the country, then you may have just gone on an exercise that wasted people's time. We in the opposition have realized the serious concerns of this bill and the serious implications of this proposed bill. And we are in the business of providing responsible criticism as well as coming up with different solutions that we can propose. Because this bill presents itself in a very unique way that it needs a 3/5 majority in both houses, we are going to inform when we get your contributions. We are going to collaborate, we are going to collate, and we are going to sit and discuss as a caucus the views expressed by the members of the public, and then it will inform our decision as to how we vote when it comes both in the lower house and most importantly when it comes to the upper house. So even though they might not be all right, there's no political meeting, but because they didn't know how to run it, we are showing them how to run it here today.
Thank you, MP Marcelle. And we have another question there, Alderman.
Good night. Welcome to the great borough of Point Fortin. And in Port of Spain, I gave trouble, and I am sure to give trouble again today in Point Fortin. And it's not really a question, but more so an observation. And I hope that our MPs here, senators here, can raise. And I saw some reps from the MP for Point Fortin here as well. And I do hope they can take some of these notes to Mr. Kiza to raise on our behalf in the parliament as well. In that when this entire conversation started, since 2 years ago by the then opposition leader, now Prime Minister, it was sensationalized, empty the clip, problematic, knock it on them again and again, and using truly bad language as policy. And it was repeated ad nauseum in the elections this year. And when you observe this bill, and when you hear we dissect this bill, you realize that there is no matic. You are unable to knock it on them, and there's no clip to empty. And therefore, what I am seeing here is a scandalization of the bill and a misrepresentation. And that is very dangerous, because when you go out there to the public, the common man, and you use these terms and you use these words to aggravate the population, they will therefore think that they have free reign to shoot how they please. We know in this country that there is a serious issue of anger. Somebody can say that their car is a property, they get a bad drive, and because they get a bad drive so bad, you empty the clip on them. And clearly, the bill does not provide for that. So therefore, you are putting people in further legal implications. And one more concern I have is that you have ministers of government, a minister of defense who can't defend himself, is saying to the people that you could shoot even if they're running from the back. If you can't see the face and they run away, you could shoot. This is a dangerous thing to be saying in the public domain. And I would like to ask if the panel can probably comment on that particular comment that I'm quite displeased about. So I do hope that these concerns are registered and that the government can come clean to the population and stop with this disruptive lingo that they are going about in the public domain. Thank you very much.
Thank you, Alderman Kobe Sandy. Senator John Bates.
Yes. So, Alderman Sandy, I would like to wholeheartedly endorse what you would have indicated, and particularly zoning in on that issue of shooting someone running away in the back. The bill itself speaks to defensive force, and it defines defensive force as justifiable and reasonable use of force by a person acting in self-defense, in defense of property, or in defense of another. Is it justifiable and reasonable if someone is running away from you, so the threat has now dissipated, to shoot them in the back? I think that is a question, again, that the court, because I do believe if that were the case and the person dies, I feel very confident to say the police will indeed have to arrest you in that circumstance and you would be brought before a court. And again, if we look at the factors that the court has to consider when considering if your defensive force was reasonable in the circumstances, they have to look at the nature of the force or threat. If the person is running away, what is the nature and force of the threat? They have to look at the extent to which the use of force was imminent. Is it imminent anymore if the person is running away? They have to look at the size, age, gender, and physical capabilities of the parties. They have to look at whether there was a possibility that the occupants would have safely retreated. So if the person is running away, you don't even have to retreat, you have to do nothing because you're running away. Again, was that a sensible and reasonable statement to be made by a minister? Or was it just something said to be sensational, to scandalize, because she needs like Bacchanal? I don't know.
Thank you, Senator Sanjiv.
Thank you. Just to jump on your tailcoats a little bit there, as we're speaking about the Minister of, is it Defense or Homeland? Minister that made that particular statement about shooting people in the back. Alderman, what I would say is, old habits die hard. I mean, if you're telling people to say, after you've shot somebody running away from you, you're telling them to say to the police that, well, the man was going to call the partners to come and finish the job. Like I said, old habits might be dying hard on that side, right? But I would implore you from this goodly platform, ladies and gentlemen of the responsible part of Trinidad and Tobago, please do not ever shoot anybody in their backs. You will find yourself in jail without a proper defense. So don't do that. But the first part of your contribution, Alderman, invites me to propose that we look at logic. If it is that certain campaign promises were made, that is all well and good. We've had a change of administration, and with that, one would expect a different policy. And if it is the policy of the government to arm the citizens of Trinidad and Tobago, that should be said very clearly and plainly, number one. And number two, if that's the case, one would expect logic would dictate that you look at legislative review of the firearm legislation first. You would want to consider whether we have a proper framework in place that guides the process and the requirements of those applying for legal firearm. Because there is no such real framework in place. There are regulations that are put in place from the TTPS from time to time as commissioners change. In fact, not too long ago, we would have seen that the last commissioner introduced or reintroduced some old regulations that may have once been in place and had been done away with. So we don't have properly functioning legislation as it comes to gun ownership in Trinidad and Tobago. But one would think that logic would dictate that you deal with that first. If it is the government's position that this bill is necessary, it means that people right now exercise more caution in gun ownership than they would when this bill comes into place, because it means that the country is of the view that you can't stand your ground, right? That's why this bill is coming into place. It's ostensibly giving the homeowner more latitude to protect your home. So if it is you believe that they are more responsible now, we'll fix the firearm process first now, right? And then you implement some mandatory training and review for firearm owners. And then maybe last, you consider allowing them a little more latitude. And now talk about emptying clip and loading up matic and all of that. But to tell people, to excite people into the type of behavior that they seem to want to excite people into is rather irresponsible and simply illogical. It is backward. You're doing the last thing first. So I would end by what I started, or the way I started, in saying that, look, nobody's saying crime not bad. Nobody is saying that initiatives are necessary to get crime under control, but exercise responsibility in doing it. Exercise equity, exercise fairness, and consider the cultural orientation of our society, and consider where we are going when we decide that we want to arm the population, where we are going when we decide we want to put armed police in schools. Where are we going as a society? Is that the real way of dealing with crime, or is it, as the PNM continued to do, addressing the root causes of crime? So when you send home 50,000 people and the children going to school hungry, you want to now go and put 2 police in the school to keep them at bay. But that again is illogical and backward thinking.
Thank you, Sanjiv. We have the floor open here, ladies and gentlemen, but of course we have questions virtually as well. So let me take one of our virtual questions before you go in there, sir. This is coming from Ernest, and he is asking, is the legislation really needed? Wouldn't it be better to improve the current legislation on all the crimes which are likely to be committed under home invasion? Kareem? So I'm asking MP Marcelle, and Sanjiv, you could comment on it after.
Yes, sounds very kindly for the question, Vyash. The common law provides to me adequate protection for a host of defensive mechanisms that one can employ and be protected by the law. This legislation only really, one, codifies the existing common law to an extent. Two, creates an offense of home invasion, but there may be overlap. So if, for example, someone comes to your home and robs, or if you're not home and it's larceny or burglary or larceny of your motor vehicle or whatever the case may be, there may be an overlap in terms of which of the different statutory provisions the police may charge that person for or not. So what it also does, the penalty for home invasion. So if someone actually comes into a home breaking and they find themselves in one of the categories as outlined in the provisions, that person once found will be arrested and charged as a home in contrary to this bill. The consequence of same is that it is for a fine of 500,000, I believe, and up to 20 years, right? In the first instance, and if in instances where, right, yes. So section 6, subsection 2 states that a person who commits an offense under subsection 1 is liable on conviction or indictment to a fine of 500,000 and to imprisonment of 20 years. And in cases where the person, who commits the home invasion is doing this as a part of a member of a gang, or in cases where they are a participant in organized criminal activity, or in cases where there is a presence of a child, a senior citizen, or differently able person, or otherwise vulnerable person, then you are entitled. The court can sentence you up to 25 years and 750, and fine you up to 750,000. Now, not because you have very high provisions means that the court, when using the sentencing guidelines, would actually sentence you to anywhere close thereof. There may be someone who may be convicted, who might be convicted of home invasion, for example, and based on the fact that they may not have any previous convictions or pending matters of a similar nature, or it may be their very first time, may end up in a case where, if you have good defense criminal attorneys, may end up in cases where the court may give a bond or community service, or may even give you a small fine. It doesn't drastically change the sentence that is given when you look at the law. The last thing I want to point out on that is that this current proposed bill is proposing for all persons who are charged for under home invasion, for these persons to be tried before the High Court. What it means, we have to look at our justice system, and we have to determine whether, with the prevalence of home invasions, whether it is a case where we want to flood our high courts, which usually would deal with serious matters such as murder, such as rape, and serious indictable matters, whether we want to add this on to the list of our high court judges, and thereby extending the length of time that you would take to get trials in cases of murder, rape, and serious misbehavior in public office, and those kind of charges. So we have to look at that and to see in comparing whether this bill really would achieve this purpose.
Thank you, MP Marcelle. Sir, we have another question.
Good night once again, David Tate, presiding library. Sunday gone, we were lying under the lazy man tree. And this was the discussion. Now, senior counsel from the other side said, no more will the victim have to prove that he acted in self-defense. Now the law will presume that the victim acted with lawful justification. In other words, the law will say, you come in this man's house, we are asking the man, no question. And that left us perplexed. And I would like my learned lawyers here to explain to me, because this is a man of SC telling me that once the man come in your house, you can shoot him. So if I go by my neighbor who is a UNC and I open my door and say, hello, don't shot for me because he's a PNM. Please explain this. What is that dangerous thing this man said, and he's a senior counsel?
Sanjiv?
Right. So, I mean, to make it very clear, sir, nowhere in the legislation does it say, anything the way that it has been phrased. There is, look, under no circumstances is there not going to be an investigation. Already, the police have obligations to society. They have no choice. Insofar as the government wishes to say there will not be an investigation into the facts surrounding a shooting death, there is going to be an investigation. The question really is whether the police are going to determine, or whether the police are going to decide to allow the court to take the obligation under Section 7.2 to determine whether defensive force was reasonably used in the circumstances. In other words, whether after the investigation, the police are going to form the view that this person needs to be arrested because it is more likely than not that the homeowner acted unreasonably or acted disproportionately toward the alleged home invader. And once that is the case, an arrest is going to happen, you're going to be put before the court, and the court is going to take into account the nature of the force or threat, the extent to which the use of force was imminent, and whether there were other means available to respond to the potential use of force. Doesn't that sound like retreat to you? Let me read it again. Whether there were other means available to respond to the potential use of force. Whether there was a possibility that the occupant could have safely retreated, notwithstanding the fact that there is no duty to retreat. In other words, the court is going to say
I understand that you're not obligated to retreat. But in that story you've given me there, sounds to me like you had several chances to retreat. And you chose not to do so. You chose to load up your Matic, and I'm going to read the words then. Load up your Matic, light them up, empty the clip, and when you're done, knock it on them, knock it again, then call my name. I am Kamla. Do not fear. Kamla is here. 22nd April 2025. Word for word. So I waited for the day that somebody is trying on this legislation and they go and they say Kamala in defense, you know. Because she invited the population to behave in that way. So I hope that that answers the questions. So thank you, Sanjiv. And ladies and gentlemen, certainly a very interesting and gripping conversation here in Point Fortin tonight. But unfortunately, we are coming to the end. We may have time just for one or two more questions. I would like to raise, okay, we see two persons on their feet, so both persons will have the opportunity to pose your questions. So, please.
Good evening, everyone. My name is Dexter Bowen, and I hail from Point Fortin. My question is this. Shouldn't laws regarding both firearm usage and firearm crimes be addressed, debated, and amended before stand your ground is even introduced as a supposed remedy to magically solve crimes like home invasions?
Senator?
Yes, I think Mr. Boodhu would have eloquently addressed that before, but I would just want to reiterate that yes, Mr. Boodhu essentially would have said that they have put the cart before the horse. He didn't use that phrase, but that is essentially what he was said. We should have indeed addressed our firearm laws before we get to this point. Mr. Boodhu would have indicated all the reasons why that should have been done. Right now, we have a lot of policies guiding FUL acquisition instead of proper regulations. We are telling people, well, the rhetoric anyway, not necessarily what is written here, that when they come, load up the Matic, yet we are not addressing how many people are going to get these guns, how to get the guns, what they should do in terms of gun safety, storage, education. These are things that should be addressed before we turn this place into a wild, wild west.
Thank you. Yeah. Yes, sir. Name, location, and question, please.
Good afternoon. My name is Fitzroy Beach, Chatham, original. I'm trying to understand certain things here in this meeting. And it has me mind-boggling. Because when them men jump your fence and come inside, them don't want to know if it's a UNC or if it's a PNM. Them men coming direct to you for whatever they're coming for. You understand? So that, I feel I get that out of the way. You understand? Just today, I read on a newspaper that crime is down. From 2025 by 42%.
Sir, can you speak into the mic there, please?
Sure. Yeah. In 2024, it was 469. In 2025, it's 270, down by 42%. So something showing me like crime going down. You understand? Now, I understand it when people, the first thing I feel they should do is change the gun laws. They're waiting too long to get law. I'm done. You understand? And that will create this problem in Trinity. Because you could get a gun easy from Venezuela. You understand? You could get man-making gun. So I feel they should change some of the gun laws and the waiting process. It's too long. I know man die waiting on gun, FUL. Man die. They do it so long that they waited on it and they die. You understand? So I believe we have to change up some laws and do this thing better. And I think coming like how people feel a man will come to your door. Everybody reasonable. A man can't come to your door and say good night and you shoot it. You have to be real. As if a man coming to rob you, or they even ask if they come to rob you, they come in to rob. So you have to be ready. You understand? That is my contribution.
Thank you, sir. Sanjiv?
So I heard you say, sir, that you read is it a newspaper article that you referred to there, sir? Yes. Right. I'm happy that you referred to a newspaper article because as at the 17th of September 2025, which was the day before our first consultation, or the day of our first consultation, there were no statistics available on the TTPS website for 2025 for any crime. So we now getting our statistics from what somebody says to a reporter that is published in the newspaper, which is exceedingly concerning. But I'm happy that you raised the question of statistics. Because I have some statistics here too. So in the years 2015 to 2024, for the crime of robbery, there was a 514 number reduction. That's 18% reduction over that period. And for the same period, 2015 to 2024, larceny dwelling house reduced by 125, which was a 53% reduction. Let me repeat the period, 2015 to 2024, and we're talking about two crimes here. Larceny dwelling house, that means somebody breaking into your home, and robberies, that means somebody breaking into your home and robbing you, or robbing you outside your home somewhere else under different circumstances because the category is broad. So, I mean, these are the two offenses that will be relevant to our discussion on home invasion. So if it is from 2015 to 2024, we have reductions of 514 in one and 125 in the other. I'm wondering why it is no 2025 statistics was put out, especially for the first quarter of 2025. Right? I'm also wondering overall, why is it that we have no statistics at all published by the TTPS on their website being made available to the public, and we now have to rely on newspapers as being accurate. Not at all to call into question the newspaper, because as I said, they're getting these statistics from somebody. So we have to ask ourselves whether the source of the information is correct at all. So that's my bit on the statistics there. Thank you.
Thank you, Sanjiv. And before we close off, I would like to ask a question that we received online, virtually, and this is coming from Kevin. And Kevin asks, how does this law relate to someone who stands their ground against a relative or in a domestic situation? Senator John Bates.
Yes, thank you. Upon reading this bill, I concluded that this bill, these principles, as the defense of standing ground and the self-defense does not arise in domestic situations. I say it, well, generally, and I say that because it says here under section 10.1 as an exception that section 7 and 8, which applies to stand your ground and self-defense, does not apply where a person against whom force is used or threatened has the right to be in or is an occupant in the dwelling house. And when we look at the definition of occupant, it is very broad. I think it addresses most domestic situations, because in most of a domestic situation is one where the parties tend to generally, they live together. They are lawful residents of the home. So if you're lawful resident in the home, then you're an occupant, and another occupant can then shoot you and then say, well, I'm standing my ground against you. You're both lawfully in possession of the house. Taking you again, just to make it clear, the definition of occupant. You have the owner, occupier, tenant, or any other person having control or management of the dwelling house. An immediate family member of an occupant who resides in the dwelling house either temporarily or permanently. A person who resides either temporarily or permanently in a dwelling house with the express permission of an occupant, and so forth. So that covers most domestic situations. So this law will not protect you from standing your ground against a common law partner, a husband, a wife, a child, and so forth.
Thank you, Senator. Sanjiv?
Just I endorse what the Learned Senator said. I'd just like to add in respect about wider category of persons who might be considered extended family members, relatives, friends, and so on, right? So section 6(1) says, subject to subsection 3, a person commits a home invasion, D, who is invited into an occupied dwelling house and fails to leave immediately on being asked by an occupant to do so. So imagine a situation where somebody has invited you to their home, lime going on, whatever, all fours, match still in sour, until I get out immediately, right? You gotta run, exactly, because it says leave, fails to leave immediately, right? And then there are some other qualifications. And let's go to H, intentionally causes any injury, right? So let's say the person is asked to leave, get out of the house. And he say, a bottle pelt. That is intentionally causing any injury. Immediately you have committed an offense under this act, right? You committed home invasion under this act. Now, the homeowner now, armed with his firearm, cutlass, or otherwise, decides to stand his ground, as it were. And the police come and intervene and arrest the homeowner because, be demand to frazzle, he hospitalized, he concussed, whatever the case is, right? The court shall take into account the nature, duration, and history of any relationship between the parties to the incident, including any prior use or threat of force and the nature of that force or threat, whether either party has ever applied for or obtained an order against the other in accordance with the Domestic Violence Act. So that covers what the senator said. Any history of interaction or communication between the parties to the incident. And of course, the nature and proportionality of the occupant's response. All right, so that's a real situation that happens in Trinidad and Tobago. People get very upset at family engagements and get into physical altercations and so on. Is it that we want to give persons the ostensible assurance that they could act in a particular way, especially if you're looking to load up matic and so on, and that is you're inclined that way to arm yourself? Is it that we really want to be considering that sort of rhetoric, encouraging that type of behavior, and then at the same time coming and saying, but you know what, here, what now, the court is going to consider whether these situations, these pieces of particulars have arisen, whether you know the man, whether he's your brother-in-law, you know what I mean? These kind of situations have to be taken into account. So the law says, well, even if you feel you might be acting in self-defense and standing your ground is jail for you. So what does that change about the current situation? Because people know that there are boundaries. So even in the all fours match that break out, there is right now proportionality that exists. So what is this law really fixing? What problem we have that this law is curing? It is telling people, go ahead and behave in a certain way. But when you behave in that way and you call Kamala name, it is not a sufficient defense. Hail.
Thank you, Sanjiv. And ladies and gentlemen, I want to thank you. This has certainly been an informative session, and you have been such a very welcoming audience and very inquisitive as well. So, ladies and gentlemen, point Fortin, can you give yourselves a round of applause for your participation in today's national consultation on Stand Your Ground legislation hosted by the People's National Movement? It has certainly been enlightening, and I know the MPs, the senators, those there, I even saw the political leader taking copious notes, and I know she has been very much informed and listening to all of you, not only here, but also on social media as well. And I think you could rest assured that your views, your perspectives, and your comments would have been listened to. Ladies and gentlemen, can we also give a lusty round of applause for our panel, our distinguished panel, esteemed, very well-learned attorneys, and bringing that perspective and bringing that insight into Stand Your Ground legislation. Ladies and gentlemen, to bring closing remarks on today's consultation on Stand Your Ground legislation, I want to introduce someone who has been demonstrated strong leadership and resilience and vision in the past and currently and will in the future in managing some of the country's very complex challenges. He holds leadership positions in the People's National Movement as our current chairman, as the chief whip in the House of Representatives, and is currently the Member of Parliament for Aruka Lopino. Ladies and gentlemen, Point Fortin, please welcome and give a round of applause for the Honorable Marvin Gonzalez. Thank you very much, Vyash. Let me recognize my political leader and the leader of the opposition, our political leader and leader of the opposition, the Honorable Penny Beckers Robinson, for this fantastic initiative. And my other colleagues in the leadership of the party, Dr. Nyan Galsby Dolly, Patricia Alexis, our deputy political leader, Ms. Jennifer Baptiste Primus, and Point Fortin people. Thank you for coming out tonight and being part of this very engaging educational session that we in the PNM are only too familiar with. This is not no Sunday night or Monday night forum. This is an opportunity to engage the people of Trinidad and Tobago with information regarding our affairs, the way that which we manage ourselves in this country. We've been to Port of Spain. On the second one, we were in Shugwana Central, and we are now in Point Fortin. And we intend to journey throughout Trinidad and Tobago to engage you, the citizens of Trinidad and Tobago, on this very important matter of stand your ground. The process is that, according to the directive given by our political leader, is that the PNM's position will only be finalized after we have sufficient consultation with the people of Trinidad and Tobago, following which a report is going to be generated, and that report is going to be presented to the General Council after we listen to your views as expressed in these consultations. And after the report is deliberated at our General Council, then our party's caucus in the lower house and in the upper house will have a position on what the government is presenting in this stand your ground legislation. So I want to thank you very much. This is a very important exercise, and it's very important for members of council and those of us who represent communities, those of us who represent people, to come to these sessions and listen to the views as expressed by the people, because this, after listening to those views, we will generate a position based on these consultations. There are two things that I want to bring to your attention before I close. I was informed not too long ago during these consultations, because people, when you visit and you participate in these consultations, people meet you at the side and they're not wanting to be part and coming before on microphone and cameras. But I was informed that part of the government's agenda in this stand your ground legislation is to bring additional legislation to remove the powers of the police commissioner from issuing firearms in Trinidad and Tobago. I would have mentioned time and time again in our caucus that if we are not careful and allow ourselves to be distracted by this stand your ground bill, we would lose the general picture. So you have this stand your ground bill, and then you have spokespersons of the government saying if someone is running away from you, you can shoot them in the back. And then he quoted a former judge who said in open court that it is better for 6 persons, or rather for you to be judged by 12 persons than to be carried by 6. You understand what he's saying? It is better for you to be judged by a jury of 12 men if you are charged for murder than to be carried in a coffin by 6. Very important thing. And then you hear the Prime Minister saying, blow them up into pieces, kill them violently. And then you hear a government spokesperson saying that we are going to establish gated communities. You have to understand where they are going with this singular bill, Stand Your Ground. It is part of a package of what the government intends to do in Trinidad and Tobago. 85 days ago, the Prime Minister was quoted in The Guardian, and this is what she said. They believe additional measures and safety and safeguards are needed to ensure that every applicant is treated fairly and assessed based on the merit of their need for an FUL. During the appearance at the UNC's Monday night forum at the PNM Secondary School, Prasad Bisesa lamented that there have been occasions where some applicants for firearms were rejected based on a single police officer's opinion or reasoning. And then she go on to say, she stated that such a process was unfair and vowed to introduce legislation to change the procedure. And our information is that they intend to bring legislation to remove the discretion of the police commissioner, introduce a commission that is going to be chaired by a board appointed by the government of persons who they can control, so that they can decide who get firearm and who don't get firearm in Trinidad and Tobago. This is where they are going with that. And you just only have to look and see who they are appointing on the board. Very soon they are coming with this legislation to remove the discretion of the police commissioner and to put in its place a board, a firearms board that the government will have control over. That is where they are going. So we'll be very, very foolhardy to focus this discussion on Stand Your Ground. The government is diabolical and they have a well-orchestrated plan to introduce the agenda in Trinidad and Tobago, and an agenda that is going to disrupt our social fabric. The next thing I found was very interesting was that in 2 days ago, the Express newspapers ran a guest editorial of the Gleaner newspapers. And the headline was, Gangs, War Within the Law. Gleaner newspapers, Jamaica. And the Gleaner newspapers, they quoted at length Dr. Andrew Holness, address at the UN General Council recently, and Jamaica's strides that they are making in reducing crime by 51%. But this was what is very interesting. And the Gleaner newspapers are saying that in Jamaica. The government of the Caribbean community have long, I'll start from here. Government and law enforcement experts attributed upwards of 70% of the murders to inter-gang feuds as they engage in reprisal killings of fights for turf. The vast majority of the killings with guns, mostly imported illegally from the United States. This is what the Gleaner newspaper is saying, that Prime Minister Andrew Holness, in his address at the UN General Assembly, their activities undermine people's sense of security, destabilize communities, and place a drag on economies. The governments of the Caribbean community have long accepted the dangers posed by gangs as part of a network of organized crime and have called for international support to help confront the problem. The United States in particular has been repeatedly called on to do more to limit the flow of firearms into the Caribbean region. However, Dr. Holness has begun to pose the question of gangs as a global problem in the Caribbean. He told the General Assembly, Jamaica has made significant progress in tackling gangs and reducing our homicide rate by more than 50% in recent years, but we know that unless these networks are totally dismantled, our games remain fragile. And Dr. Holness said that what Jamaica did was not to introduce Stand Your Ground legislation, but they tackle it from at various points. dealing with the social issues, dealing with prison reforms, dealing with the policing and the corruption in policing, dealing with prosecutorial matters. And the Jamaican government, in dealing with all of these issues by introducing legislation to tackle it from a holistic perspective, saw a reduction in crime and murders in particular by 51%. And nowhere did the Jamaican government introduce to their people stand your ground legislation. Tonight, the People's National Movement continue to tell the government that you cannot bring stand your ground legislation as the panacea to solving the crime problem, that you have been voted into government, that you have told the people of this country that you can solve the problem. Show us your legislative agenda. And as the honorable leader of the opposition said when she was sworn in on the very first day, we will work with the government on any piece of legislation that will advance the circumstances of the people of Trinidad and Tobago. That's what we are saying. And the opposition is saying that tonight, show us your legislative agenda that is going to tackle all of the societal issues that contribute to crime in Trinidad and Tobago, similar to what was done in Jamaica. And don't come with a piece of legislation where you know that the main agenda in this stand your ground legislation is to empower a certain group of people in the society who stand to make hundreds of millions of dollars in profit by the sale of firearms, because they happen to be the financiers of the United National Congress and destabilize the social fabric of the people of Trinidad and Tobago. So we in the PNM will do what we must do to represent your interests, but we are not going to be distracted by this stand your ground legislation, because the road to hell is paved with good intentions. Thank you very much. Thank you, MP Gonzalez, Chairman of the People's National Movement. Ladies and gentlemen, this brings us to the end of our national consultation on Stand Your Ground legislation hosted by the People's National Movement. We thank you all for coming out. We thank His Worship the Mayor for hosting us here in the busy, bustling borough of Point Fortin. We thank the PNM and especially led by the political leader for having the vision and foresight to have a national consultation on such an important piece of legislation like this, to listen to you, the members of the public, and to the citizens of Trinidad and Tobago. And ladies and gentlemen, we thank you all again for coming out here tonight. And as I conclude, I wish you all safe travels home. Thank you and good night.
God was a friend, and we like it like that. Coming on my life like snake in the grass.
Power, feel the power, power, power. DJ, touch it, bring